All right, good morning, everyone. I'd like to call to order the Judiciary Committee meeting for Thursday, March 30th, 2023. Time is 10:01. We are going to break for caucuses. The Democrats are in room 2D. The Republicans are in 2600. We will stand in recess until after caucus. All right, good morning, everyone. We'd like to reconvene the Judiciary Committee meeting for Thursday, March 30th. Happy opening day of baseball. Go Red Sox. Mr. Chair, any remarks? If not, let's jump right into it. We will start on item number 1 on our agenda. House Bill number 6877, an act concerning risk protection orders or warrants and disqualifiers for firearm permits and eligibility certificates based on temporary commitment under a physician's emergency certificate, JFS LCO number 6528. In a second.
Second.
Motion from Senator Winfield, second from Vice Chairman Quinn. We, as folks know, this legislature passed an update to our nation-leading risk protection order statute a year or so ago. That public act has had its desired effect, which is it has increased the number of risk protection orders that are being applied for by our police departments in order to take guns out of the hands of those who are a danger to themselves or to others. As a result of that uptick, both our police departments and our court system have asked for certain modifications to the statute in order to streamline the process. And that's what the bill before us does. Is there discussion? Representative Howard?
Thank you, Mr. Chairman, and good morning to you, sir. I just a couple of very quick questions. So it seems in the first section that we're going to go from 2 officers down to 1 to get an RPO, right?
In order to file the application, that's correct.
And then, so with 1 officer applying, the judge could issue the RPO. However, as I read lines 19 to 21, if they need an actual warrant to search a person or place, it would still have the 2 affiant requirement that currently exists for search warrants.
That's correct.
So that's basically done so that we can sort of streamline, if you will, or limit the burden on police officers for RPOs, but we're keeping our current practice of ensuring that we have 2 affiants when we're going to search a person's home.
Yes, sir.
All right. So then I jump down to section 2. And I think, Mr. Chairman, we're in agreement that that's how we do all search warrants, right? Joyce warrants, we do that for if you want to get medical records from the hospital, phone records, it always is 2 affiants, right?
That's my understanding.
Right. So then we go to section 2. And as I read that, it says that upon complaint by any police officer, singular, the beginning of it, that an individual jumping down to line 282, such child possesses 1 or more firearms, and such firearms or deadly weapons are within any person, place, within any place, thing, or person. Such judge may issue a warrant commanding an officer to enter upon such place or thing. So it seems like in section 2, we're abandoning our current practice and the one that we were careful to keep in place in section 1 of ensuring 2 police officers are affiants for when you're conducting an actual search warrant. But in this case, now we're going down to 1. And am I missing something, or can I have some explanation as to why we're doing that?
Section 2 only applies to juvenile proceedings, not to adults. And the thought here is that we're talking about a juvenile who possesses a deadly weapon that they shouldn't be in possession of, as opposed to having the higher, shall we say, burden of search and seizure with an adult who otherwise would be in lawful possession of that deadly weapon.
Okay, so I'm in agreement with section 1, and frankly, I actually don't substantively disagree with section 2, except for that fact, because if you have a child, and I don't think too many children own homes, if you have a child that falls under this because the officer has some probable cause to believe that they have a weapon, they've maybe made a Snapchat post, they've made an Instagram post, something like that, that their parents' home, a search warrant can be issued for their parents' home upon the complaint of a singular officer. We do that nowhere else. and I understand that we're trying to achieve this for juveniles, and if it was a single officer for RPOs, but the two officers be necessary for the protection of individual civil rights, then I would be all for it. But I just don't understand why, just because we're going to juveniles, that now we're going to limit the state's burden to enter somebody's home from a one officer affidavit or from a current two officer standard down to one for an actual search warrant. I don't understand why we're doing that.
So, Representative, what I would submit to you is if that becomes a stumbling block and you want to add back in after this bill clears this committee, two officers, certainly in order to enter a home of a parent, I'm happy to add that back in there. As I'm sure you're aware, this proposal actually came to us from the Police Chiefs Association and a number of our local police departments in order to streamline the burden, particularly on our smaller police forces in dealing with these matters. But, you know, I think there is a difference between a juvenile who is in possession of a deadly weapon outside of the home. But if you want to draw a distinction for an actual search of a home, I would be amenable to that change as we move forward.
Well, I appreciate it. And because as I read it, this says that if the weapons are within, I'm on line 284, within any place place, which would be a home, thing, or person, such judge may issue a warrant commanding police officer enter into or upon such place, which would be a home. So we're going to issue search warrants for the government to come into people's homes, whereas everywhere else we do it with a one officer or with a two officer, two affiants required. And here we're going to one. So I appreciate your response. I guess my question is, did CPCA explain why they felt it necessary to go to a one officer for a search warrant in those situations?
I don't know that they weighed in specifically on this latest language. This bill has gone through a few different iterations.
Okay, well, I appreciate your answers, and I hope I'm all for. I understand our red flag laws. I understand what we're trying to fix here. I understand the burden it's been on police officers, and I am hyper focused on not overburden our police officers, make sure they can get a good job done. But I pause at starting to limit what it takes to get into somebody's home. So I appreciate the fact that you're going to be amenable to it. I'll vote no today to flag this, and I look forward to, I think, get your word. I'm sure we can work that out. Thank you, Mr. Chairman.
Further questions or comments? Representative Fishman.
Thank you, Mr. Chairman. Just had a question about lines 271 through 272. And I don't know if it's a stylistic change, but talking about deadly weapons, presently the law says means a deadly weapon as defined in section 53A3. However, we are making an affirmative change that says has the same meaning as provided in that statute. Is there a reason for that change? I don't know if that's an LCO question or...
I mean, if LCO is able to answer it, we can direct it to him. It looks like a stylistic change to me, but LCO.
Yes, I would characterize it as stylistic and technical.
Okay, so just to be clear, we are not changing the effective use of the term. And the
Yeah.
reason why I ask is directing one to a particular statute which has a list,
Mhm.
I take that as being exclusive. But then when we change that affirmatively and we say same meaning, in my mind, it softens it. So something could be akin to something that's on that express list presently. And certainly when we're dealing with something, we're dealing with what is a deadly weapon, right? And what needs to be addressed here. I just want to be clear for legislative intent that we are not substantively changing anything here by this language change.
Correct.
Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments from the committee on this? Further questions or comments? Seeing none, Madam Administrator, please call the roll.
A roll call vote on House Bill 6877 to JFS it to the floor with LCO 6528 Winfield,
Winfield, yes.
Statstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel,
Yes.
Fishbein, Blumenthal,
Blumenthal votes yes.
Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney votes yes.
Dillon, Doucette, Jubitsky,
No.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
Yes.
Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan, Labriola,
Labriola votes yes.
Lesser, Mar,
Mar votes yes.
Miller,
Sorry, Miller votes yes.
O'Day,
O'Day, yes.
Osborne,
Osborne votes yes.
Havelock Tomato, Porter, Sampson,
Sampson is no.
Sims,
Sims an affirmative.
Veach,
Beach is a no.
Walker, Wilson.
Thank you. Madam Administrator, we will hold the votes until 4 o'clock today. Item number 2, Senate Bill number 3, an act concerning online privacy, data, and safety protections and an employer's duty to discharge known instances of sexual harassment or assault committed by an employee when making employment recommendations. This will be a motion for JFS. The LCO number is 6517.
Second.
Motion from Senator Winfield, second from Representative Quinn. Senator Winfield.
Thank you, Mr. Chair. The bill before us and the JFS before us puts in place the standards for sharing and access to consumer health data. It deals with the requirements for around the personal data of young people on social media. It deals with the issue of geofencing of health data, prohibiting it. It also codifies in statute the Connecticut Internet Crime Against Children Task Force. What the JFS language did, just in case people on the committee don't know this, there was a section of the bill, section 13, that had a lot of discussion back and forth. That section has been removed, and that was the section that dealt with the requirement on the part of employers to disclose known instances of sexual harassment and assault when making employment recommendations.
Is there discussion on the bill? Is there discussion on the bill? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 3 to JFS it to the floor with LCO 6517. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel,
No.
Fishbein,
No.
Blumenthal,
Blumenthal, yes.
Callahan,
Callahan, no.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette, Jubitsky,
No.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
No.
Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan, Labriola,
Labriola votes no.
Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes no.
Osborne,
Osborne votes yes.
Havelock Tomato, Porter, Sampson,
Sampson is no.
Sims,
Sims, yes.
Veach,
Beach is a no.
Walker, Wilson.
Item number 3, Senate Bill number 953, an act concerning the definition of racial profiling, JFS LCO 6529. Motion from Senator Winfield, second from Senator Kissel. This bill redefines racial profiling based on the recommendations of the CT Racial Profiling Prohibition Project Advisory Board. Is there discussion? Seeing none, Representative Fishbein.
Mr. Chairman, very brief.
Hold on,
Sorry.
Representative Fishbein, do you yield to Representative Howard?
Yes, sir. Thank you.
Representative Howard?
My apologies, Mr. Chairman. I just wanted to recognize, often folks come up here to public hearing testimony and they ask me, is it even worth it? Is anybody listening? And the fact in this bill is a great example that there was public hearing testimony. The chairman of the advisory council was here. We had a great dialogue and he made a promise that he would answer the question and come back, and he did. And I'm grateful to see that he kept his word and that we ended at a great place. And I'm happy to support this legislation today. So I just wanted to mention that for anybody who may be listening.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we create a consent calendar and that we move SB 953 and act concerning the definition of racial profiling to such consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, so ordered. Item 4, Senate Bill number 1117, an act providing protection for persons who have been trafficked and additional measures to prevent trafficking in persons. I'll entertain a motion for JFS LCO number 6306. Motion from Senator Winfield, second from Senator Kissel. This bill contains a few different items, the first of which is one that's been before us before, which would prohibit motels from offering an hourly rate. It also requires hotels and motels to establish a person's identity by checking their identification. And it adds the Commissioner of Developmental Services to the Trafficking in Persons Council. Is there discussion on the bill? Is there discussion? Seeing none, Madam Administrator, please call the roll.
Roll call vote on Senate Bill 1117 to JFS it to the floor with LCO 6306. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel. Fishbein. Blumenthal,
Blumenthal, yes.
Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney, yes.
Dillon, Doucette, Jubitsky,
Yes.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Hall,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola,
Labriola votes yes.
Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day votes yes.
Osborne,
Osborne votes yes.
Havelock D'Amato, Porter, Sampson,
Sampson is no.
Sims,
Sims votes yes.
Beach,
Beach is a yes.
Walker, Wilson.
We're going to move to item number 6 on our agenda, Senate Bill number 1196, an act concerning procedures of the Department of Corrections related to strip searches and transfer of prisoners who are incarcerated between correctional facilities. I'll entertain a motion for JFS LCO number 6526. Motion from Senator Winfield, second from Senator Kissel. Senator Winfield.
Thank you, Mr. Chair. So before us is the JFS to the bill that originally was looking at the issue of changing the standard to do a search in our prison system to probable cause. What we are doing here, there were 2 parts of it. Let me start with the first part, which was about the transfers. So there have been issues with not notification on transfers, both for those who have been the victims and for family members. I can tell you that I had a constituent who had an issue. We couldn't really find out where someone was. So this deals with that and making notification as we should have been making. On the issue of the strip searches, what we're doing here is saying to the Commissioner of Corrections that 2 things. There will be a report that comes by February 1st of 2024. If you know when our next session exists, you know that's the beginning of our next session that will come by February 1st of 2024 to the committee on the procurement of body scanning machines for use in the system. Also, on or before the beginning of the year, January 1, there'll be the commission will make a request for proposals for the procurement of the body scanners. In addition, that's not just because this is an important issue that's not in the bill. There will be an engagement with the department on their administrative order as it pertains to body searches. Depending upon where that conversation goes, there will be potentially a follow-up bill to do some of the things that we're intending to do. I would just say this to those listening. Whatever an individual did, I think we all recognize that we have human beings in our prisons, and they should be treated as such. And that is not to say that there is intention to do one thing or another, but that we should be, as a legislature, very concerned about what's happening in our prisons and how people come out of our prisons. And with that, Mr. Chair, I'll take any questions.
Thank you, Senator Kissel.
Thank you very much, Chairman Staffstrom. Good morning, everyone. I'm in favor of this bill. I appreciate the work that's been done to it. As folks are probably aware, I have more correctional facilities in my Senate district than any other state senator. And even though due to reductions in population, we've had some of those facilities mothballed for the time being. One of those facilities, McDougall Walker, in the wonderful town of Suffield, is actually the largest correctional facility in all of New England. So matters affecting prisons have always been of great importance to me, given the nature of my district, as well as concerns on this committee and overseeing the Department of Corrections. I think moving in a direction where we study the issue of utilizing essentially metal detectors or detectors that can assess what is in a person's body is really important. I don't think anybody would disagree that a strip search is demeaning and dehumanizing, and yet we have to balance that with the need to make sure there's no contraband allowed into the facilities, not only for the protections of corrections officers, the men and women whose boots are on the ground, but also other inmates that want to live in as safe an environment as humanly possible. And that's what we strive to do here in Connecticut. Over 90% of inmates eventually are released back into society. And so we don't have a death penalty anymore in Connecticut, so no one should have their life imperiled while they're serving time in our correctional facilities. As I envision it, and this may change with input from all the stakeholders, but if we could utilize technology to do this analysis in the vast majority of circumstances, that would just make the work of the corrections officers more efficient, more cost effective, less burdensome to do these things, which probably is unpleasant in and of itself, but also taking away this dehumanizing, demoralizing necessity for having to do strip searches when you have visitation or just moving from one building to another, or other matters where it's done as a matter of course. Of course, if someone would refuse to walk through one of these machines, or there's areas where the policy would dictate that it's not the most effective way of maintaining safety in the facilities, then that's a different situation. But I do think that down the road, the world that I envision here in Connecticut is where this is utilized as much as we humanly can, while maintaining that balance between safety and respecting people's humanity who are serving time. And when they serve their time, they are released back and hopefully becoming productive, law-abiding citizens in our state. And so for that reason, I think this is a great step forward. It may not be exactly on the time frame that advocates had been hoping for, but I think it's a tremendous move forward for the state of Connecticut. I commend the leadership of this committee for working on this as well. Thank you very much, Mr. Chair.
Further questions or comments on this, Representative Fishbein?
Well, thank you, Mr. Chairman. I first want to thank Senator Kissel for his extremely eloquent remarks regarding this legislation. I really couldn't have said it better myself. That balance, protection of staff as well as inmates is very important. I also want to take a moment to thank the many members of corrections that had reached out to me in advance of the public hearing and shared with me the administrative order that's currently in place. You know, if I was to listen to the public testimony in a vacuum, I would have been of an understanding that you know, strip searches are happening on a daily basis, on a whim, things like that. And certainly if those things are happening, that's actionable because that'd be in violation of the administrative order. So I was happy, comfortable to be able to review the administrative order, to look at the confines under which presently strip searches are to happen. I'm certainly very happy with the notice provision of this legislation. It's something that I've been advocating for a while, is not only of the family of the victim, but also the family of the incarcerated should know where where the individual is being housed. And I know the Department of Corrections website is not real-time data. I've seen that firsthand on many occasions. So, you know, I look forward to seeing this report about this electronic shift, you know, whether or not it's workable. I know in other states it is. And I think it's a good thing. So thank you, Mr. Chairman.
Further questions or comments? Representative Porter?
Thank you, Mr. Chair. I don't know where to start. Scanners are an important piece. I will say that. I do believe that that is a very viable option. I'm looking forward to what comes forth from the RFP when it goes out. But for me, there is a whole bigger issue around the people who are incarcerated and what they're being subjected to and what they're going through, what they have been reporting to us, what they have come before this committee and testified to. You know, one thing to say is what advocates are hoping for, but I've been talking to incarcerated people and I just want to speak for what they've been hoping for. And I can tell you that this is part of it, but this is not all of it. It's an inhumane practice, no doubt about it. And the further I delve into this and the more research I do on it, what I'm finding is more than disturbing, it's dangerous. We keep talking about safety and security. And the reason that we do these strip searches is for the purpose of safety and security. But it's a two-sided story to that, because what we are saying is that that's really on the incarcerated people. But we also know that there are reports and there have been arrests, that it is also the people like the correctional officers that work in these facilities that have been arrested for bringing in contraband. You know, there's reports of cash apps and money being sent to accounts for exchanges that we know are totally illegal. So I want to make sure that as we move forward, that we are addressing this in a way that is most meaningful. And it's not just the fluff, you know, feel good, because I asked a question during during the public hearing to someone around the cavity searches, which is very disturbing to me to learn that that is something that is actually being done past the point of just having to strip down and do these things that are required to do during a strip search that are totally humiliating. Garner facility, it is my understanding, and this is, and I'm putting these things on the record because I want answers, definitive answers from the Department of Corrections, which I haven't gotten yet. So I'm hoping that this will prompt that to happen. I'm being told that Garner facility, that they are actually cut out of their clothes when they get strip searched. Then on another instance, I'm being told that that only happens if you resist or don't comply with the strip search. I asked about the cavity searches. I was told that those searches are done in medical, which led me to believe that it was being done by medical personnel. I've been told by people who have been previously incarcerated, are home, and have gone through these strip searches at York female facility. You're taking the medical, but the cavity searches are done by COs. They're recorded. There are male officers that do the recording. It's a violation. So my concern at this point is, in between now and the time we get back this report in the language as written, what are we doing to address the issues that have been brought to our attention? And I will say my attention specifically, through you, Mr. Chair.
Senator Winfield.
Thank you, Mr. Chair. To the question on the floor, that is the second part that's not in the bill. That is the discussion between this committee and the Department of Corrections to work on changes to the administrative directive. As I suggested in a conversation not before this committee with Representative Porter, should we not be able to make the progress intended, then the issues that are brought before the committee now to have that conversation and make those changes would show up in a bill. I just want to say to anyone listening, I don't think we intend to have administrative directive or a statute that says that you, for instance, would take someone to medical, and the intention of that would be that a medical professional is doing the work, and because it's not explicit enough, or people are creative, that they get around it. And so we're going to engage in a conversation about that. We're going to engage in a conversation, as some of you may know, there are conversations about removal of a biscuit leading to a strip search, and the many things that I think, regardless of what the administrative directive or any statute currently says, may be going on in our system, and see if we can make progress. And if we can't, then we'll try it by legislation. And if that doesn't work, like the many other things we work on, we will come back again and again and again, through you, Mr. Chair.
Representative Porter.
Thank you, Mr. Chair, and thank you, Senator Winfield, for that response. And I hope that is exactly where we go with this, because my concern is that in between now and another year, these practices are still in place, and the incarcerated people in the state of Connecticut are still being subjected to not just inhumane treatment, but I mean, it's demeaning what happens and what's being reported to us. I can't imagine going to my GYN doctor and having the receptionist do my physical exam. And that is pretty much what has been described to me. So I'm hoping that these issues get addressed sooner than later. And I look forward to the conversations outside of this committee that we will have to get this right. Thank you, Mr. Chair.
Thank you. Further questions or comments on this bill? Further questions or comments? Seeing none, Madam Administrator, please call the roll.
A roll call vote on Senate Bill 1196 to JFS it to the floor with LCO 6526. Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal,
Blumenthal, yes.
Callahan,
Callahan, yes.
Conley, Curry, Delaney,
Delaney votes yes.
Dillon,
Uh,
Doucette, Jubitsky,
Yes.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
Yes.
Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola,
Labriola votes yes.
Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock D'Amato,
Havelock D'Amato votes yes.
Porter, Sampson,
Sampson is yes.
Sims, Veach,
Veach is yes.
Walker, Wilson.
All right, next, we'll move to number 8 on our agenda. Point of order, Representative O'Day.
Just briefly, I know we're in a hurry, but as you may recall, last year, I kept the committee here late in discussing recreational marijuana. And as a commitment, an apology, I said that I was going to buy the committee and staff pizza. It has taken me a year, but based on some of the items on the agenda here today, I figured it might be a good time for me to buy the committee and staff pizza. So there is now pizza for the committee and staff. Sorry, I don't have it for everybody. I know my mom always taught me if you're going to buy something for someone, you got to buy it for everyone, but I can't afford pizza for everyone. But there is pizza in room 2600 for committee members and staff as an apology for me keeping everyone here on the recreational marijuana. And as an early, tomorrow's my birthday, so I didn't want to buy it on my birthday, so buying it today. So anyway, little gratuitous slap on the back there for my 29th birthday.
Well, we will refrain from singing to you, Representative O'Day, but we do wish you a happy birthday, and the record will reflect that you're a man of your word and kept to your obligations to provide pizza for the committee. So we appreciate that. All right, number 8 on our agenda is SB number 1231, an act concerning a defendant's competency to stand trial and early release into the community. I'll entertain a motion for JFS LCO number 6537. Motion from Senator Kissel, second from Senator Winfield. Discussion on the bill. Seeing none. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move SB 1231, an act concerning a defendant's competency to stand trial and early release into the community, to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Number 10, House Bill number 6734, an act concerning the decriminalization of possession of small amounts of psilocybin. JFS LCO number 6328. Motion from Senator Winfield, second from Representative Quinn. This bill decriminalizes psilocybin in a manner very similar to the manner in which this legislature decriminalized cannabis some 10, 11 years ago. Psilocybin would still be not be fully legalized under this bill, but possession of under half an ounce would result in a fine of $150. A subsequent offense would be a fine of between $250 and $500 and referral to a drug education program. As folks may know, at the direction of this legislature last year, the Department of Mental Health and Addictive Services provided a report to the legislature concerning the benefits of psilocybin to a person's physical and mental well-being, and noted research that demonstrates psilocybin to be a promising treatment for some behavioral health conditions, including substance use, depression, and palliative care for end-of-life anxiety and depression. Also, psilocybin is under consideration for approval by the Food and Drug Administration as a drug to replace, in many respects, prescription painkillers. This is a substance that I know from my discussions with my constituents is being used by individuals instead of painkillers as a way to deal with PTSD, end of life issues, pain and suffering from burns, and any other number of uses. So while this bill does not go as far as full legalization, while it does not provide for recreational use, and while it does not provide for a medical treatment program, psilocybin, what it does do is recognize the fact that possession of this substance should not be treated as an our highest level, a misdemeanor, that it should be treated differently than something like heroin or fentanyl, and has a medical benefit to it. And so therefore possession would be an infraction as opposed to punished by up to a year in prison, which it currently is punishable as. Questions or comments on the bill? Senator Kissel.
Thank you very much. And so it's my understanding that psilocybin is also colloquially referred to as hallucinogenic mushrooms. Is that correct?
Some may, that's true.
Okay. And so my concern with this is, and there was not a lot of testimony regarding it, is from talking to some folks, it appears that there still is a tremendous amount of vehicle accidents in the state of Connecticut, vehicular deaths, and we wrestled for quite a while trying to figure out when we as a legislature, I opposed it, but regarding the legalization of marijuana, cannabis, however you want to refer to it, and its interaction with alcohol, or as a standalone substance in one system when one is trying to drive a motor vehicle. And my concern primarily with this, there's other issues too, but by moving in this direction, while I was an advocate for the medical use of marijuana, and to the extent psilocybin, hallucinogenic mushrooms, or some other form of this substance, I have no doubt has medical utilizations. Certainly, I am very sympathetic if someone's in end of life, but I do believe in miracles as a human being. Anything can happen, and we have stories of that all the time if you look for them. But pain and suffering and things like that, if this is another way, I'd be much more comfortable with a specific carve out for the medical use of this substance as opposed to simply decriminalizing it, so that if you wanted to use it recreationally, you could too. You might find yourself being fined, but certainly I understand the proponent's desire not to make it require one to serve time in prison. Okay, I get that. But as a public policy, I just don't have enough information as to its interaction with alcohol, or alcohol and marijuana, or in marijuana. I don't know whether our law enforcement officers have an ability to judge someone who may be driving erratically, whether they may or may not be under the influence of this substance. If it is hallucinogenic by its very nature, by how we refer to it, you're going to be seeing something that's either not there or amplified in some way. And my guess is since you really need to have good vision and be aware of your surroundings when you're driving a vehicle that may be in excess of a ton of weight at speeds that may be 60 miles an hour on our highways, you may in fact, intentionally or not intentionally, probably negligently, be risking the lives of either yourself and your passengers, or other law-abiding citizens on our roadways. So we're moving in a direction. I sort of get where it's going. It sort of naturally flows from the legalization of marijuana. It's not surprising that this shoe is now dropping now as well. And my guess is with the decriminalization down the road would be legalization. I get it. But I have concerns primarily with the public safety issues, especially on our roadways. And also what I had stated regarding the legalization of marijuana is, what does this tell our young people? And we have this huge death rate in our state with people overdosing with fentanyl. So you have some drugs that are just really deadly, and yet we're moving in a direction of just lowering the bar for possessing and utilizing other drugs that may have deleterious consequences that the users may not really know. And are we inviting a new generation, young people, to experiment with this to sort of see what's going to happen? Because, hey, if I get busted with this stuff, I'm going to get $100 ticket, and that's not a big deal. I will say this anecdotally, in talking to younger people, they tend to be much more reserved about outside substances than maybe I was growing up, not me personally, but the generation I grew up in like the 70s. they, especially because like we tell them, avoid cigarettes and vaping is bad. So they're very much aware of a lot of these issues. So I have great confidence in the younger generation. Don't get me wrong. But again, we in setting policy are sending a message out to the greater public. And I think it's, if anything, a mixed message when it comes to drugs and things that will affect your ability to function clearly, at least with the, and my constituents view driving as a right, but I guess it's legally a privilege. But certainly, you know, when you're out there in society, some things require you to be at the top of your game to the extent that you can. We all get aged, we all get older, God willing. Although we haven't, you know, get infirmities and stuff like that. I mean, just the process of walking and talking on the planet Earth, you know, getting older is not the most pleasant thing when it comes to your ability to function. But this isn't going to help that unless it's ameliorating some of these consequences, especially pain and some of those other things. So we haven't really spent as much time on this as we did with marijuana. We spent years on that issue. And I just think that we're just sort of now delving into a new area without a lot of background information. And for that reason, while I respect the proponents' advocacy, I'm going to be voting no on this because I just don't think that the data is out there for me to feel comfortable with this change. Thank you, Mr. Chair.
Thank you, Senator. And I just want to be clear for the benefit of the members of the committee and for those who may be tuned in. Our driving under the influence laws are not changed under this legislation. So driving under the influence of psilocybin will still be driving under the influence. That is still unlawful. There is no change to that. And in fact, there's actually conforming language in this bill to make clear not only would you face the normal driving under the influence penalties, but also a license suspension as a result of psilocybin. So driving under the influence of psilocybin would be treated the same as it is now as when this bill, if this bill passes. The only difference is the mere possession. Possession would be treated differently. Instead of being an A misdemeanor punishable by up to a year in prison, it would be treated as an infraction. But otherwise, possession of psilocybin or driving under the influence, I should say, or sale or possession of more than half an ounce or paraphernalia, all of those other prohibitions remain intact, unchanged under this legislation. Representative Fishbein, do you have a question?
Yes, thank you, Mr. Chairman, and I thank you for that that explanation. And not to speak for Senator Kissel, but I believe the concern is that when you say to the general public that possession and therefore use of a substance that is generally untested, I mean, the feds are looking at it, may lead to more deaths on our highways. And it's really not of solace to me that one can't be that the law doesn't change, you know, somebody can't be arrested for driving under the influence, because, you know, unfortunately in many of these instances somebody's dead and you can't bring them back. So it's not solace to me that, well, they're still going to get arrested for driving under the influence. So bad things happen when people operate motor vehicles under the influence. But I wanted to ask particularly about the penalty aspect of this, understanding that currently possession is a Class A misdemeanor, correct, Mr. Chairman?
That's correct.
And this would, you know, I guess our penal system is, you know, starts with an infraction, which is, you know, a low form ticket. We don't arrest people for infractions. And this is something above that. Is that fair?
What do you mean by this is?
Well, should this legislation pass, that the individual would not be arrested as they would presently, it's lowered to just above an infraction. It's a fine. It's a ticket. You pay a fine.
Yeah, it's a $150 ticket on a first offense. It's a $250 to $500 ticket on a second offense. And also, if you plead guilty to the first two offenses, there would be a referral to a drug education program.
Okay, thank you. Thank you for that clarification.
Further questions or comments? Representative Drabitsky.
Thank you, Mr. Chair. In the same way that there is a breathalyzer test used by police to test whether or not a driver is impaired with alcohol, is there any type of test to determine whether somebody is impaired with psilocybin?
My understanding is it's similar to any of the other drug recognitions. So no different than how we test or look for someone who's under the influence of heroin or cocaine or cannabis or any other illegal substance.
Okay, so it's some type of recognition system as opposed to a test of some sort. Through you?
Yeah, and I believe in addition, there's also, I believe it is initially a recognition to determine whether it's probable cause, and then there could also be a urine or blood test.
Okay, thank you. So the just so I'm clear, so psilocybin does come up on a urine or blood test through you?
Through you or to you, Representative, I'm not entirely sure of how it manifests or the timeline by which it manifests, but I will tell you again, none of that changes under this bill.
Okay, thank you very much.
Further questions or comments? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 6734 to JFS to the floor with LCO 6328. Winfield,
Winfield, yes.
Staffstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel. Fishbein. Blumenthal,
Yes.
Callahan,
Callahan, no.
Conley. Curry. Delaney,
Delaney, yes.
Dillon,
Dillon, yes.
Doucette,
Doucette, yes.
Drabitsky,
No.
Elliott,
Elliott, yes.
Gaston,
Yes.
Gilchrist, Godfrey,
Yes.
Paul,
No.
Harding, Hayes, Howard,
No.
Johnson,
Yes.
Khan, Labriola,
Labriola votes no.
Lesser, Mar,
Mar votes yes.
Miller, O'Day,
O'Day votes no.
Osborne,
Osborne votes yes.
Pablock D'Amato,
Pablock D'Amato votes no.
Porter, Sampson,
Sampson is yes.
Sims, Beach,
Beach is a no.
Walker, Wilson.
Miller votes yes.
Thank you, Senator.
Number 11, House Bill number 6735, an act concerning conveyance of title to real property in matters involving a decree of annulment, dissolution of marriage, or legal separation. I'll entertain a motion for JFS LCO number 6134. Motion from Senator Winfield, second from Senator Kissel. Discussion. Representative Fishbein.
Thank you, Mr. Chairman. I'm in support of this bill. I do recognize that it's a five-year provision. I really think it should be quicker. Maybe we can work towards that. Under this language, basically what happens is that somebody gets divorced, and in the judgment of the court, whether it be by agreement or after trial, there's a conveyance of property, and the transferor of the property doesn't act. So now you have somebody who's supposed to receive property, and they're calling for someone to take an affirmative act. This would allow one to take the judgment and to record it after a 5-year period on the land records to show that they should have the property. I mean, I'll tell you, I do run into this. I think we should be working towards a 6-month provision, but I certainly am fully in favor of where this legislation is, and hope we can work towards that. So thank you, Mr. Chairman.
Further questions or comments on the bill? Further questions or comments? Representative Fishbein again?
Yes, thank you, Mr. Chairman. I move that HB 6735, an act concerning conveyance of title to real property in matters involving a decree of annulment, dissolution of marriage, or legal separation be moved to the consent calendar.
Is there objection to placing this item on consent? Is there objection? Seeing none, so ordered. Number 12. House Bill number 6797, an act concerning the receipt of workers' compensation benefits and the provision of medical records in workers' compensation matters. I'll entertain a motion for JFS LCO number 6522. I have a motion from Representative Quinn and a second from Senator Winfield. Representative Quinn.
Thank you, excuse me. Thank you, Mr. Chairman. This is the substitute for 6797, which is a bill that I've introduced. The major changes to it are that Section 2, which dealt with plan benefits, is now Section 1. The new Section 2 was Section 3 and concerns medical records and the access and timeliness to them and the appropriateness of any fees. And what we're doing in Section 2 is forming a working group made up of appropriate stakeholders to address that issue. Some valid concerns had been raised to me by representatives from the third-party medical record collectors about who exactly should be fined if records are delayed. So we'll work that through. And then Section 3 is the old Section 1, also forms a working group to deal with the issue of whether there should be adjustments made to the amount of 308A benefits, which are partial permanent benefits that a injured claimant could receive. And that also forms a working group. And under Section 1 at line 28, I'd like to make a friendly amendment that we change the word "and" to "or," which will appropriately match the legal standard in workers' compensation, which is reasonable or necessary.
Okay, so there's a motion to change the word "and" to "or" in line 28. Is there a second? Second from Representative Howard. Is there discussion on the amendment? Is there discussion on the amendment? Seeing none, let me try your minds. All those in favor signify by saying aye.
Aye.
All opposed, nay. The ayes have it. The amendment is adopted to line 28. Now, on the bill as amended, is there discussion on the bill as amended? Seeing none, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I move that we move HB 6797, an act concerning the receipt of workers' compensation benefits and provision of medical records and workers' compensation matters to the consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, so ordered. Number 13, House Bill number 6888, an act concerning juvenile justice. I'll entertain a motion for JFS LCO 6535. Motion from Senator Winfield, second by Senator Kissel. Senator Winfield.
Thank you, Mr. Chair. What this bill before us would do is it's going to expand the community-based diversion system when a child has a violation of certain of our statutes. The ones listed here are simple trespass, larceny in the sixth, creating a public disturbance, disorderly conduct. If the child is not successful, they may be referred back to the court from the Juvenile Review Board for delinquency proceedings. It expands the use of automatic pre-arrest diversion for youth. It also expands the membership of the Juvenile Justice Policy Oversight Committee. You may often hear us refer to that as the JJPOC. Will include new members. It also deals with the commissary plan of our young folks. And the implementation of that commissary plan deals with the transition from DOC to the judicial branch, and it also has language dealing with the issue of the Alvin Penn racial profiling, which deals with pedestrian stops. Mr. Chair, thank you.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chair, I just had some questions initially, focusing on.
I think
section-
Senator Winfield is ready.
Thank you. Am I to understand that section 1 precludes a member of, precludes a child from being arrested for certain crime?
Senator Winfield.
I think the child would be arrested. How they are handled, I think, is different after the arrest.
Okay, well, I just want to point your attention to line 5, where it's expressly says in lieu of arresting. So I think in every other area of the law, when we say in lieu of, that means instead of. So am I to read that differently?
Representative Fishbein, I think you are correct in what the language says. I think in order to move the child, we may want to look at the language to make sure that it clearly suggests what we're saying. I think what we're trying to get at there is that the child does not go before the court before having, at least for those particular violations of statute, before finding themselves at the Juvenile Review Board and then potentially getting referred back to the court.
Okay, so I recognize there may be significant work that needs to be done on this language, but moving forward from there, assuming that the language expressly says in lieu of arresting, what is a child as described in line number 5?
Through you, Mr. Chair, as that section is laid out, it doesn't have a definition of child, so I would have to refer back to a general definition of child. Representative Fishbein, there are other sections of the bill that refer to child. Again, I believe that we mean the same in terms of reference as later in the bill where we refer to a child under, I believe it's 46B-120. But if we need to clarify that, I believe we are perfectly willing to do so.
Understood. I'm, this is just line 5 of this bill. Assume 46B-120, I believe, defines a child as anybody under the age of 18. Is that fair?
Through you, Mr. Chair, that is correct.
Okay. So moving forward, still with line number 5, understanding that and I'm just going to read that clause. In lieu of arresting a child for a violation of section 53A-110A, I'm just stopping there. 53A-110A, as you correctly identify early on, is simple trespass. Simple trespass is an infraction. So since when do we arrest anyone for an infraction?
Through you, Mr. Chair, I don't believe that that's the normal course of operating. I believe I will probably answer your follow-up questions the same way. I think that in drafting this bill, there's an intention of what we want to do. I'm not sure that the drafting is absolutely dead on. I would be happy to engage you in conversation, which I know we will have right now, but I'd be happy to engage you in that conversation after the committee to address all of the concerns with the drafting.
I appreciate that. And I will recognize that this bill is 866 lines long, and we are just on line 5. Moving forward from there, 53A-125B is the next statute that this law in line 5 says that a child is not supposed to be arrested for. And I think you correctly pointed out that that is larceny in the 6th degree, correct?
Through you, Mr. Chair, that is correct.
Okay, and larceny in the 6th degree means stealing property with a value of less than $500. Okay, so a child cannot be arrested for stealing property value up to $500. That's what this says, correct?
Through you, Mr. Chair, as it's currently written, it does say that the child under the construct of the bill would be made to be before a juvenile review board and potentially find himself in court. Yes.
Okay, so the Juvenile Review Board, since you did mention it, I think it's important to talk about that. How many times would the child get not arrested for stealing up to $500 and continually go before the Juvenile Review Board? I didn't see that it said, first time, second time, 30th time. Where in this language can you point me to that it's just not a revolving JRB?
Thank you. And through you, Mr. Chair, I don't believe the language before us explicitly says time number 2 or time number 35. It does, however, say that if the child is not successful in completing requirements imposed by the Youth Service Bureau or community-based provider, that they might find themselves in front of a court. I would suggest that any of those requirements would include not being arrested for that crime or not being detained or arrested for that crime again.
I respect that, but the timing is important here. So let's just say this past Monday, a 17-year-old stole $499 and they're not going to get arrested. There's going to be a referral to the JRB. How long does that process take?
Thank you. And through you, Mr. Chair, off the top of my head, I don't know exactly how long the process takes.
So
I'd be happy to get you that answer.
Sure. I think every JRB around the state is different. I think that's fair.
Through you, Mr. Chair, I would say currently that is, yes, absolutely correct.
Because there is no standardization of procedures for JRBs, correct?
No.
So let's just say it's 30 days. So Monday, this 17-year-old stole $499. Now, they haven't gone before the JRB before Tuesday. If they steal another $499 on Tuesday, can they be arrested under this language? To you, Mr.
Thank you, and through you, Mr. Chair. As the language currently sits, it does not appear that they would be able to.
And then Wednesday, and then Thursday, and then Friday. So it goes on and on until they get to the JRB, and the JRB tells them, don't steal anymore. And then they perhaps do steal again, and then they can be arrested. That's the way this language lies, correct?
Yes, it lies that way, although I've never seen a situation quite like that. Yes, it does.
Well, okay, so let's talk about what larceny 6 is. Because when we look at the statute, it expressly says, and it's not very long, a person is guilty of larceny in the 6th degree when he commits larceny as defined in 53A 119, and the value of the property or service is $500 or less. So we have to go to 53A 119 to find out what larceny is. Larceny is extortion. It's one of the things under 53A 119. That's sub 5. Extortion is compelling or inducing another person to deliver such property to himself or a third party by means of instilling fear in him that if the property is not so delivered, the actor or another will cause physical injury to some person in the future. So on and so forth. There's many other ways that extortion. So now it's not only stealing, but it's the child in high school who says to the other child, give me your sneakers or I'll kill you. That's extortion. That is, under this law, a non-arresting offense. On subsequent days in our schools across Connecticut. That's what this legislation does. It permits a 17-year-old to call a grandma and say, unless you give me $499, I will harm your grandchild. That's extortion. Expressly in the language. It's troubling. I don't know why. Certainly not my public policy. I can understand some low level, the simple trespass thing makes sense, right? But I don't know why this legislature would possibly be contemplating making extortion of up to $500 a non-arrestable offense for a 17-year-old. And then we wonder why kids are stealing cars. Just saw one yesterday, right? Child died in Waterbury. There's 4 kids, 4 juveniles, stolen car, and they tried to get away from the police, and one of these young men drowned. It's laws like this that create those problems. Yep. You're not going to get arrested. You're going to go to the JRB. Just keep on doing it. The next statute that says child's not going to get arrested for is 53A 181A, which is creating a public disturbance. And on its face, you would think it's innocuous, but you must look at what is that? Engages in fighting or in violent, tumultuous, threatening behavior. Now, once again, I don't understand the actions of the drafters because it's an infraction. Presently under our law, child can't be arrested for violating it anyway. I don't get it. So why are we now creating a law that says in lieu of arresting the child, you're going to do the JRB? It's already the proceeding. It's already the procedure. Is somebody looking to hide the extortion aspect? But then perhaps, those of us that are concerned about domestic violence or voyeurism or, women being taken advantage of, or you have to look at the fourth of these. 53A 182. Disorderly conduct. Expressly says when you commit simple trespass, which we've already dealt with. Now it's right in the statute. So when you commit simple trespass and you observe in other than a casual or cursory manner another person without the knowledge or consent of such other person, while such other person is inside their dwelling, as defined in section 53A 100, which is basically says where they sleep at night, and under circumstances where such other person has a reasonable expectation of privacy. So baked in here is the simple trespass. Open front door. 17-year-old walks in to their neighbor's house, is hiding in the closet, watching the occupant of the home undress themselves. Now, maybe it was a coincidence that they're there at that time when that action is happening. And maybe the first time it was a mistake. But that's not how this law says. This law says that if it's a repeat activity, they can't get arrested. Now, even if they did, now, I mean, if they got arrested, they're not going to jail. That's our procedure. Even if somebody who gets arrested goes to juvenile court, most of them don't go to jail. They get services. I've had those cases. I had a case where it was a sex situation. And I was sort of happy that the child got arrested because he got some services. Somebody who's entering other people's dwellings, peeking in their windows repeatedly, I think they need some services. I don't understand. I thought public policy in Connecticut was a little bit different. You know, the middle part of this bill, I need not spend time. But Mr. Chairman, I'd like to switch to the end. We dealt with section 1. Let's deal with sections 9 and 10. The legislation before us will call for appropriations. However, how much? What is the amount that is being appropriated potentially in section 9?
Senator Winfield?
Through you, Mr. Chair, a couple of things. The bill, like many of the bills that come before the General Assembly, may not have that dollar amount in the bill. We produce things called fiscal notes that answer that question. This bill clearly will find its way over to another committee that happens to be the committee that the chair of the committee inside of the bill chairs. That would be the Appropriations Committee and the JJPOC. I just want to take a moment, though, since there were certain things put on the record, to suggest that for each of the things that were mentioned, the horribles that were mentioned, there are other statutes that capture those things. If someone communicates a threat with the intention to harm someone, you could be charged, for instance, with threatening in a second degree, completely arrestable under this bill. I'm sure that the questioner knows that. He is one of the best when it comes to what our statutes say. So I just want to make sure that the members of the committee recognize that the intention here is not that you're barred from capturing everything that might be captured by the particular statutes that are laid out there, but the simpler stuff like having a fight where you use for instance, where you use statutes we have to catch up our youth and probably shouldn't, through you, Mr. Chair.
Representative Fishbein, further on sections 9 and 10.
Sure, I would like to just address the portion about trying to soften the horribles. You know, the grandma who gets the call, who is threatened to have something very bad happen to their grandchild, I'm going to almost guarantee you they're not going to have the means to record that message. However, they're going to act on it. So in that case, because there was no evidence of the actual threat, there's no recording, probable cause would lead the police officer to merely arrest the individual for extortion. If they had the recording that led to the act of grandma giving $499 to this individual, then they would not have probable cause for mere threatening. But moving forward to that, you know, I can understand when we have holes, when you're going to go buy a service. You know, we're going to go buy, I don't know, safes for DRS to put all their money in, right? That's going to generate a fiscal note. Because you're going to have to, you know, how many safes are we buying times, you know, whatever, this is generally the number. But, I must respectfully say that these provisions have to do with giving money to a third party. it says appropriated to OPM to fund organizations for the purposes of assisting members appointed to the JJPOC for certain things. So I've never seen a blank like that in legislation for something like this, because, you know, at some point that's going to be calculated, and I would have expected to that be calculated or at least capped at some point before today. So, you know, public policy wise, I cannot in any way, shape, or form support this bill that's before us. So, thank you, Mr. Chairman.
Further questions, comments? Representative Walker.
Thank you. Thank you, Mr. Chair. And I thank the good gentleman for his concern and interest in how we craft this bill. There are some changes that have been addressed that we have been working on and trying to define a little bit more of the details that are necessary for people to understand. But first, I want to let you understand where the premise of this bill comes from, and then I will address the blank for appropriations. The bill is trying to address a population that seems to be evolving more and more from our schools and from the pandemic. Kids that do silly things that after one time, they immediately have been given a case within the judicial system. And the research has shown us that once a child touches that judicial system, it starts to go downhill for that child. What Connecticut is trying to do is trying to create a solid system of diversion so that when the child touches that hot stove, we immediately address it before it escalates into some of the examples that the good gentleman has mentioned today. We talked to a lot of the nonprofits in the community. We talked to the public defenders and the prosecutors. In fact, the prosecutors have a system, what they do in some of their jails and some of the courts now, where they talk to some of the criminals before they actually get charged. And there's a discussion going on and the negotiation to try and keep them, again, out of the court system. This is working with our children that have been excused from school, I guess, in an informal way for the last 3 years, and who need to have that formality put back in their lives. We're not saying that they can be excused for 3 and 4 and 5 times, but it means that we set up a diversion system that is funded and in place to address the children at the first go when they get caught. There are many times where our YSBs have been working on this, and they have also said that they need more funding to address it through the YSBs and through the JRBs. We are still working on the dollar amount. There have been some people that have given us quotes, but we cannot accept quotes until we get a little bit more detail on exactly how many people and where we are going to do this. Are we going to set it up as a pilot? Are we going to set it up in all the courts? It still is evolving in that regard, but the main thing is to try and establish a program that is duplicated in multiple neighborhoods and multiple communities, especially in our major municipal cities, that help the kids not get into the judicial system, but get the help they need. I know many people saw a lot of the car thefts and everything, but there were a lot of stories behind some of the car thefts. And the ones that did not get out really were the ones where the kids stole cars for a place to live, or kids that stole cars because they had no way of actually taking care of their brothers or sisters. We've got to make sure that as our kids get caught up in these I guess activities, that we're giving everybody an opportunity to get the right direction so that we don't end up clogging our systems with more. So I say that the blank, which is in section 9, in appropriations, we get bill after bill after bill after bill after bill that have the blank, and it's up to us to figure out what that blank is. So as this bill moves through, with your good help in helping to define some of the things so that you are comfortable with the idea of giving children 1 or 2 opportunities before they really go down that slippery slope, we have the necessary services and programs in the areas to address that. And at this point in time, we're not ready to say exactly how much because we have not gotten all of the details from that. So through you, Mr. Chair, thank you very much.
Thank you, Representative Walker. Thanks for clarifying that and for your advocacy and work on this. Further questions or comments on the bill? Further questions or comments on the bill from anyone who has not spoken on the bill? Representative Fishbein, briefly for a second time.
Yes, Mr. Chairman, just once again, focusing on section 1. Police officers already have that discretion. We're taking it away. Once again, taking away the discretion for referral to a JRB. Sorry, I got something in my throat. But I do have a question. What about those municipalities that do not have a JRB? What is to law enforcement to be with those to do with those individuals when they believe that they have committed one of these crimes?
Representative Walker, would you like to take the question?
Sure, I would love to. We are working with Department of Children and Families at this moment to establish and make sure that the main municipalities in the state have an established JRB and a YSB. Those programs are being redefined, and we are working with the existing YSBs and JRBs to make sure that it is one system and not multiple systems throughout the state. And I'm sure the good gentleman can understand that we've had the YSBs and JRBs in our municipalities for a while, and we are now going to make sure that we have a uniformity in the way that we address it. Thank you, sir.
Does that address your question, Representative Fishbein?
Yeah, I heard that it's being addressed in the major cities. I'm still concerned in the non-major cities. Given that this is supposed to become effective July 1, what most members of law enforcement do at that point, but I guess we'll figure it out then. So
Further
thank you.
questions or comments on the bill? Further questions or comments? If not, Madam Administrator, please call the roll.
Roll call vote on 6888 JFS to the floor with LCO 6535. Winfield,
Winfield, yes.
Dahlstrom.
Yes.
Flexer. Quinn,
Yes.
Kissel. Fishbein. Blumenthal,
Blumenthal, yes.
Callahan,
Callahan, no.
Conley, Curry, Delaney, Dillon, Doucette, Dubitsky,
No.
Elliott,
Yes.
Gaston,
Yes.
Gilchrist,
Yes.
Godfrey,
Yes.
Hall,
No.
Harding, Hayes, Howard, Johnson,
Yes.
Khan, Labriola,
Labriola votes no.
Lesser, Mar,
Yes.
Miller, O'Day,
O'Day, no.
Osborne, Pavlock D'Amato, Porter, Sampson, Sims,
Simpson affirmative.
Beach,
Veach is a no.
Walker, Wilson,
Osborne votes yes.
House Bill number 6889, item number 14, an act concerning juvenile matters. JFS language is LCO 6391. Motion from Senator Kissel, second from Representative Fishbein. The JFS language strikes most of the underlying bill. I believe The only piece that is left is the part that restores the family with service needs petition process. My understanding, again, this is a service that has not been funded, so this will be another bill like the last one that will have to go to the Appropriations Committee in order to see if it can get funded. Is there discussion on it? Representative Fishbein?
You know, I'm surprised that those that care about children not going to jail had apparently got rid of this program in 2020 through lack of funding. Basically, what this does, is it gives an outlet for a parent who has a child at home who is out of control. They can't handle, is not going to school, is drinking, drugging, all that stuff. Allows that parent to call their local youth and social services board or group. They would apply to get the family involved with this program. It's the Family with Service Needs program, and administered through the juvenile court, but it's not before a judge. It's assigned to a probation officer who works with the young man or young woman and tries to set them on a different path without them being arrested or doing bad stuff. This is a bridge. I can't tell you how many parents I have contacting me complaining about this program or something like it not being available. Especially through the pandemic, we saw a lot of different aspects, mental health with kids and that kind of stuff. I think this is a vital program to have that bridge. So I hope those that deal with this after this committee look at it in a favorable light, and I am fully in support. So thank you, Mr. Chairman.
Senator Winfield?
Thank you, Mr. Chair. I would just say that there was a policy discussion as well as a budgetary discussion. And while there may not have been a bill, there was a policy discussion about whether or not the system we had worked. The budget discussion, if you understand how things work sometimes, clearly is reflective of the policy discussion. Having said that, I will be voting to send this bill to the Appropriations Committee to continue the conversation where it rightly belongs, given the framing of the conversation. And I think that everybody involved in looking at the issues for our youth should be looking at not only what we have had, what we intend to have, but anything that might help our youth. That might not be called what we used to call it, might not look like what we used to look at, but that can help our youth. So with that, Mr. Chair, thank you very much.
All right. Further discussion on this, Representative Walker?
Thank you, Mr. Chair. And I thank the good gentleman for continuing the conversations about our juveniles, because that to me makes, as long as we're talking, then we're making good decisions and moving in the right direction. However, I think part of the reason why this entity was not maintained was because of the problem with the fact that a lot of kids were getting criminalized in this process, and truancy was one of them. Girls being out of control was another. And I think it needs a lot more clarity that makes the child the most important entity in this process, as opposed to trying to just move the child out into another system. That was one of the problems, and we can work on this. And I look forward to working with the good gentleman, because again, I say, as long as we're talking about our children and keep them in the forefront for the issues, as opposed to trying to move them out of the stage, it's the most important thing that we continue this way. So with that, I will support it out of committee today and look forward to working with the good gentleman on his bill. Thank you.
Thank you. I just want to clarify, based on the discussions we've had, that this is a JFS to the floor. Obviously, it's our expectation that will end up being referred to appropriations, but this is not a JF to approps. This is a JF to the floor is the motion. Representative Walker.
Thank you, sir. If we know that there is a cost in the bill, then the bill should be going to appropriations. Am I not correct on that, sir?
To you, Representative Walker, I'm sure since it will require an appropriations, it will get screened over to approps as any of the rest of our bills do, but we JF our bills to the floor and then screening
Oh.
will send it.
Sorry, my bad. Thank you.
All right. But certainly it is expected that screening will send this to appropriations after at least here, since it is an unfunded program and will generate a fiscal note. Madam Administrator, please call the roll.
Roll call vote on House Bill 6889 to JFS it to the floor with LCO 63991. Winfield,
Yes.
Staffstrom,
Yes.
Flexer,
Senator Flexer votes yes.
Quinn,
Yes.
Kissel, Fishbein,
Blumenthal, yes.
Callahan,
Callahan, yes.
Conley, Curry, Delaney, Dillon, Doucette, Dubitsky,
Yes.
Elliott,
Elliot, yes.
Gaston,
An enthusiastic yes.
Gilchrist,
Yes.
Godfrey, Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola,
Labriola votes yes.
Lesser, Mar,
Mar votes yes.
Miller, O'Day,
O'Day, yes.
Osborne,
Osborne, yes.
Havelock Tomato,
Tomato votes yes.
Porter, I think it was Sampson,
Sampson is yes.
Sims, Beach,
Beach is a yes.
Walker, and Wilson.
All right. With that, Madam Administrator, if you could read back the consent calendar.
Consent calendar consisting of Senate Bill 953, Senate Bill 1231 with LCO 6537, House Bill 6735 with LCO 6134, and House Bill 6797 with LCO 6522 and Amendment A.
Please call the roll.
Winfield,
Winfield, yes.
Staffstrom,
Yes.
Flexer, Quinn,
Yes.
Kissel, Fishbein, Blumenthal,
Yes, Blumenthal.
Callahan,
Callahan, yes.
Conley, Curry,
Yes.
Delaney, Dillon, Doucette, Dubitsky, Elliott,
Elliot, yes.
Gaston,
Yes.
Gilchrist,
Gilchrist, yes.
Godfrey,
Yes.
Paul,
Yes.
Harding, Hayes, Howard,
Yes.
Johnson,
Yes.
Khan, Labriola,
Labriola votes yes.
Lesser, Mar,
Mar votes yes.
Miller,
Miller votes yes.
O'Day, Osborne,
Osborne votes yes.
Havelock Tomato,
Havelock Tomato votes yes.
Porter, Sampson,
Sampson is yes.
Sims, Beach,
Beach is a yes.
Walker, Wilson.
All right. With that, that will conclude our business for today. We will stand in recess until 4 o'clock for members to get votes in. Also, tomorrow is our JF deadline day, will be our last day. Members will caucus in the morning, so be on the lookout for that. Although the bulletin notice says 10, we're actually not going to come in until noon tomorrow now. So the Republicans are going to caucus at 11. The Democrats, be on the lookout for an email, but we will gavel in at noon tomorrow. All right, folks, we'll see you then. We stand in recess till 4 o'clock.
Hi, Senator, can you hear me okay? Really?
Now I can.
Sorry about that.
That's
Okay.
okay.
For House Bill 6888, an act concerning juvenile justice.
Yes.
And then for 6889, juvenile matters.
Yes.
All right, you're all set.
What about the consent? Didn't we have a consent calendar?
We did. I have you marked as yes.
Oh, okay. I didn't realize it. Thank you.
Yeah, thank you so much,
All right.
Senator. Representative
Jillian.
Gilchrist.
Hi, Senator. All right. Yep, I'm ready. I missed a bunch of the beginning ones.
Okay, so Senate Bill 3,
Yes.
Senate Bill 1117,
Yes.
1196,
Yes.
what do we have? 6734,
Yes.
let's see, I've got you for 6888, 6877,
Yes.
and I've got you for this one. You're all set.
Awesome. Thanks so
Excellent.
much.
Thank you.
Have a good one.
You too. Representative Pablo Tomato.
Hello.
All right, for Senate Bill 3.
It's a no.
Okay. For Senate Bill 1117.
Yes.
I think I have you for the rest of it. One sec.
6877.
Oh, no, 6877. Yep.
That's a no.
And that's it. You're all set.
Thank you.
Thanks so much. Have a good one.
Too.
Hi, Kristen, are you on there?
Can you hear me okay?
Yeah, I just wanted to verify that I didn't miss any votes, or if I did.
Nope, you're all set.
Thank you very much.
Thanks. See you tomorrow.
Madam Administrator. Madam Administrator.
Hi, Representative. How are you?
Good, thank you, Madam Administrator. Am I recorded as having missed any votes?
Yes. So I'll start with the consent calendar. Actually, So we start at the top for you. So the first bill, 6877. You voted, you got to there. And then Senate Bill 3. I have you on this one. 953 was on consent, 1117. I have you for there. 1406. Got you on that. Got you on this one. So for House Bill 6888, and that concerning juvenile justice.
Am I recording as having missed that one?
Yes.
I'd like my vote cast in the affirmative.
Okay. And then House Bill 6889, you also missed that one. And that's
I'd
not
like to
concerning
vote.
juvenile matters. Sorry.
I'd like my vote cast in the affirmative on that bill as well.
Okay. And then the consent calendar.
What bill, can you tell me what bills are in the consent calendar?
Absolutely. So we have Senate Bill 953, which is not concerning the definition of racial profiling. We have Senate Bill 1231, which is not concerning a defendant's competency to stand trial and early release into the community. We have 6735, and not concerning conveyance of title to real property in matters involving a decree of annulment, dissolution of marriage, or legal separation. And then we have House Bill 6797, which is not concerning the receipt of workers' compensation benefits and the provision of medical records in workers' compensation matters. Those four.
Yes, ma'am. I'd like to have my vote cast in the affirmative, please.
You got it. You're all set.
Thank you, Madam Administrator, and thank you for taking care of us.
Of course. We'll see you tomorrow.
Yes, ma'am.
Hi,
How are you?
good, how are you?
Good. All right. So start from the top. So House Bill 6877.
Yes,
Senate Bill 3.
Senate Bill 3, yes.
Senate Bill 1117.
Yes,
Senate Bill 1196.
yes,
House Bill 6734.
yes.
House Bill 6888.
I'm gonna pass on that just for a second.
That's okay.
Yep.
House Bill 6889.
Same thing.
Okay. And then the consent calendar.
Consent calendar, yes. And let me just take a look. Okay, so 6888, yes.
Okay.
And then this one wasn't a close vote, was it? It wouldn't impact if I vote no. Okay, so I'm gonna vote no. No.
Okay.
Okay,
All right. All set.
thank
Thank
you.
you.
Take care.
Okay, Representative,
Hey, I'm gonna change my vote on that last bill, sorry.
on 689 from a no to a yes.
Yes.
All right, you're all set. Thank you so much.
Hi, Senator.
Hi, Jim, how are you?
It's Nate, actually.
Oh, sorry.
It's okay. Jim's on here, though. He's looking at me with a smile.
Good.
All right.
Hi.
So let's start with the consent calendar.
Sure.
The bills were SB 953.
Yeah, I got the list. Yep,
Okay.
I'm yes on the consent calendar.
Great. All right. Next is HB 6877, the RPO bill.
Is this the risk warrant bill?
Correct. Yep.
I'm a yes on that.
Okay. Next is SB3, the online privacy. There's S language that removed the concern that CBIA had.
Yeah, I'm a no on that.
Okay.
Yeah. I am a no on that.
Yep. SB 1117, which is the human trafficking bill.
I'm a yes on that.
Okay. Next is 1197. That's the Department of Correction bill.
I'm a yes on that.
Okay. 6734. That's the Psilocybin bill. Decriminalization.
Yeah, I'm a no on that.
Okay. 6888, and that concerning juvenile justice.
I am a no on that.
Okay. And 6889, and that concerning juvenile matters.
I am a yes on that.
All right, you are all set.
That's it. Yeah. All right. Perfect. Thank you.
Yeah, of course.
Thanks. Bye.